One of the biggest surprises people face after a domestic violence arrest is finding out that the alleged victim wants the case dropped. But the prosecution keeps moving forward anyway. I've seen people breathe a huge sigh of relief when they hear the victim doesn't want to press charges, only to find themselves standing in court weeks later wondering why their case is still alive. And in some situations, people make things even worse. They hear the alleged victim wants everything dropped, so they try to help make that happen themselves. A text, a phone call, a message through a friend. And suddenly, they've created an entirely new legal problem. So if you're facing a domestic violence charge in Florida, here's exactly what happens when the alleged victim wants the case dropped, why prosecutors often keep pursuing the case anyway, and the mistake you absolutely need to avoid. I'm Danny Izquierdo, a Florida criminal defense attorney. And before we talk about whether a victim's lack of cooperation can help your case, we need to clear up one of the biggest misconceptions people have about domestic violence charges. Because understanding this one concept changes how you should approach your entire case. See, the biggest misconception is that most people assumed the alleged victim controls the case. Honestly, that's a reasonable assumption. If somebody calls the police, then later decides they don't want to move forward, you'd think the case would simply end. After all, that's how most people believe the system works. But criminal cases don't work like private disagreements, and that's where people get blindsided. Once a domestic violence case is referred to the state attorney's office, the prosecutor becomes the person making the decisions, not the alleged victim. The alleged victim can tell prosecutors they don't want the case pursued. They can say they want everything dismissed. They can even refuse to cooperate. But ultimately, they don't have the authority to dismiss criminal charges. That decision belongs to the prosecutor. And once you understand that, the next question becomes obvious. If the victim wants the case dropped, why would the prosecutor continue? And the mistake that makes everything worse. Before I answer that question, I want to talk about the mistake that creates some of the biggest problems in these cases. Because this is where people often turn one problem into two. The moment they hear the alleged victim wants everything dropped, they feel relieved. And then they decide to take matters into their own hands. Maybe they send a text. Maybe they make a phone call. Maybe they ask a mutual friend to pass along a message. Usually, their intentions aren't bad. They're trying to explain themselves. They're trying to reconcile. Or they're trying to ask the alleged victim to tell prosecutors they don't want to move forward. But if there's a no contact order in place, that decision can backfire immediately, and the consequences can be serious. You could be accused of violating a court order. Your bond could be revoked. You could be taken back into custody, and now you're dealing with more than just the original case. No matter how unfair that situation feels, do not assume you can safely contact the alleged victim just because they supposedly want the case dropped. Which brings us back to the question we left hanging a moment ago. If the alleged victim wants the case dismissed, why would prosecutors keep going? The answer is actually pretty simple. Prosecutors aren't asking, does the victim still want to press charges? They're asking, can we still prove the case? Those are two very different questions. Prosecutors understand that domestic violence cases often involve complicated emotions. Relationships continue, families reconcile, arguments cool down, people change their minds. So prosecutors generally don't assume that a request to drop charges means no crime occurred. Instead, they focus on the evidence. Think of it like putting together a puzzle. The alleged victim may be one piece of that puzzle, but prosecutors are looking at the entire picture. That picture may include 911 recordings, body camera footage, photographs, witness statements, medical records, statements made at the scene, and officer observations. And if prosecutors believe there's enough pieces already on the table, they may decide they don't need the alleged victim's cooperation to continue prosecuting you. In some situations, they may even try to prosecute the case if the alleged victim never appears in court at all, which leads to another question people frequently ask. What actually happens when the alleged victim refuses to cooperate? This is where many people expect a simple answer. But like almost anything in the law, there isn't one. And that's why assumptions become dangerous. Sometimes the prosecutor decides the case is too weak to continue and dismisses it. Other times, they continue investigating and evaluating the available evidence. And in some cases, they move forward aggressively because they believe they already have enough evidence to prove the allegations. The important thing to understand is that there is no automatic outcome, no magic rule, no guarantee. Just because the alleged victim stops cooperating doesn't mean the case disappears. And this is where many defendants make a costly mistake. They stop taking the case seriously. They stop preparing. They stop thinking about defense strategy. They assume everything is headed towards a dismissal. Then weeks or months later, they're shocked when the prosecution is still moving forward. The reality is this: a non-cooperative victim can sometimes create opportunities for the defense, but it should never be your entire defense strategy. Which raises the most important question of all. What should you actually do if you're in this situation? If you believe the alleged victim no longer wants to prosecute the case, the smartest thing you can do is stay focused on your defense, not your assumptions, your defense. That means following every court order, avoiding prohibited contact, attending all court appearances, preserving evidence that may help your case, and working closely with your attorney. Because while you can't control what the alleged victim does, you can control how prepared you are. An experienced criminal defense attorney can evaluate the evidence, identify weaknesses in the state's case, communicate with prosecutors, and help determine the best strategy moving forward. And remember, every case is different. Sometimes witness statements don't line up. Sometimes evidence is incomplete. Sometimes important facts are missing. Sometimes there are legitimate defenses that prosecutors haven't fully considered. But none of those opportunities matter if you're sitting back waiting for the case to disappear on its own. If you're facing a domestic violence charge in Florida, remember this: the alleged victim does not have the power to automatically dismiss your case. That decision belongs to the prosecutor. And while the victim's lack of cooperation can sometimes help your defense, it does not guarantee that the charges will be dropped. The safest approach is to take the case seriously from day one. Follow court orders, protect your rights, and make decisions based on legal advice, not assumptions. If you'd like to learn more about the mistakes that can seriously damage a domestic violence defense, download our free guide, He Said, She Said, 3 mistakes that can destroy your domestic violence case in Florida. And if you're dealing with a domestic violence allegation that's disrupting your life, schedule a 4-point case evaluation and defense strategy. Completely free. Let's sit down and talk, because the sooner you understand what's actually happening in your case, the sooner you can start making decisions to protect your future. And that can make all the difference in the outcome of your case. I'll see you in the next video.